Chair.
Barry Coates.
Speaker, I rise to address the bill, and I'm very aware that the Part 1 of the bill has undertaken substantial change. I think we would not entirely agree with the rather optimistic view expressed by the Minister. Certainly from our perspective, the starting point for this bill was a political announcement between Prime Ministers Key and Rudd in August 2009. And that political announcement, we think, was not well thought through in terms of the practicalities. It was followed by November 2011 Cabinet's so-called regulatory framework, and we think that provided, again, an inadequate starting point for the development of the bill. Combined with a poor process and a lack of consultation, the bill that was presented to the committee needed considerable work, and I think it is to the credit of the committee that there has been a new proposal that has now been brought back to the House with a withdrawn single patent application and withdrawn single patent examination process. So we do support the fact that those elements have been dropped from the bill. We also note that there is retrospective legislation here. Retrospective legislation should be very much a last resort and should not be by any means a regular occurrence, and we're aware that there are failings in the past in not considering carefully enough the implications of the 2013 legislation. Mr. Speaker, with regard to Part 2 and the proposal for the Trans-Tasman licensing regime for patent attorneys, we do agree the need to modernise and update the original framework agreed under the Patents Act 1953. It is no longer fit for purpose. But we notice that the proposal in the bill was opposed by all 13 submissions from patent attorneys, as well as submission from Fisher & Paykel Healthcare. We think that joined-up thinking and a more, how should I say, a more complete examination of this issue would have put key elements in place before this legislation. For example, the New Zealand Trademark Attorney Scheme, a New Zealand qualification scheme for attorneys, and an extended period for New Zealand attorneys to register in Australia. And we think that to some extent the legislation is being put in place without those elements there that should in fact be there for the system to work for the advantage of New Zealand patent attorneys. We would urge the government to put those pieces in place as quickly as possible. And that will help defray some of the additional costs that are obvious of concern to patent attorneys.
Order. I am going to refer, the member sits down when I stand up. Refer members to Speaker's Rulings 52.2, but dating back to 1931, which make it clear that members must confine their remarks to the bill before the House and cannot make irrelevant matters relevant by suggesting that they should be included in the bill. So what we're debating now is the bill we've got, not other matters. And the member's been going for 4 minutes, and I think at least half his speech could have been regarded as being irrelevant. So that's a reminder.
Thank you for your advice, Mr. Speaker. I will take your advice. With regard to the bill, we remain concerned about the governance arrangements. New Zealand attorneys, patent attorneys, have to travel to Australia, for example, for disciplinary proceedings, and we consider that a New Zealand subcommittee to the governance committee would ensure that New Zealand issues aren't lost in an Australian-dominated governance committee. However, despite some of these criticisms and our concern over parts of the bill, there are significant improvements that have been made during the committee stages. For that reason, we do support the bill as amended, and we commend this for agreement. Thank you.